Hey folks, my name is Nicholas Gurney. I'm a product safety trial attorney and adjunct professor at the University of Central Florida in Orlando, and I'm doing this video today to talk about distinguishment or case comparison. It's a critical element, a tool in every trial lawyer and brief writer's tool belt, and it's really an important part of the legal profession. It's something that is important for folks to know. I think lawyers get a bad rap a lot of times, sometimes deserved, but that they are sort of these slimy folks that are going to wiggle out of any situation and that they'll argue anything. And this is an important part of arguing ethically. There's really an important element in what lawyers do when they're arguing for or against a particular result. And one way that they do that is through case distinguishment. And so the background of this concept is that the American civil justice system is based on a common law system. And essentially what that means is that prior cases help us determine how a future result will come out. So it's important to know what those prior cases say and how they might affect a case that's being decided today. And so one thing that lawyers do in legal writing is examine old cases for similar facts and different facts to try to determine whether, in our case, we're going to have the same or a different result. And obviously, it's an adversarial profession, so both sides are arguing for their own particular result. In that process, those lawyers will look at something called stare decisis. It's simply precedent, old cases that have been decided based on laws that are still on the books. And when you look at those, there's a way of examining them from a lawyer's perspective called case comparison. Lawyers will compare two cases, usually a prior case and the instant case that they're in today, to try to determine whether a particular result will come about and whether they'll have a colorable ethical argument to be made to get a particular result in their case. And so we'll talk about those ethical rules in just a moment. But first, what is case comparison? What is distinguishment? Well, it's important first to understand, sort of hard stop, that there are some cases that are binding and there are some cases that are persuasive. And that difference is important. For the cases that are binding, the court in our immediate situation doesn't really have a choice whether to follow a prior precedent or not if it's a binding precedent. In situations where the prior precedent is merely persuasive, perhaps it's out of state or out of district, it's from a different court. Well, the court in our case has some options, can choose to follow that or can choose to go a different direction. And there's a case in Florida called Pardo versus State that really sets the framework for how courts are to examine those differences. So once we get past the binding versus persuasive precedent threshold issue, hard stop, then we get into different types of analogous reasoning, comparing and contrasting two things. And one way that lawyers do that is through the examination of facts from those cases, the comparison and contrasting of those. And perhaps one of the most powerful tools in that way, in that process, is factual analogy. Factual analogy is different from rule examination, which is there's a rule, for example, that learner permits are given to people of a certain age, and someone below that age can't have a learner's permit. It's sort of a hard cutoff. Most situations that come up don't really have such a clear delineating line, 16, 17, 18 years old, whatever the case may be. There are more gray areas. And that's where factual analogy comes in, when there's not a rule that clearly decides the issue, but there are other cases that bear on the issue. And if we have cases, for example, that are merely persuasive, they don't decide the issue outright, then lawyers have a lot of room to argue, and they have to compare and contrast those cases with the immediate instant case, the case that they're in right now. And when we do that, the threshold question for me personally is, how did we get here? Is this my motion? If it's my motion, I'm sort of driving the ship initially until we get a response from the other side. And in that way, we're making the first move. We get to decide what cases we're going to include in our motion, and we have to include some cases, but others are optional that will help inform the court. But if it's the other side's motion, it's a little bit different because they've sort of made their bed. and then we have to respond. So I use sort of a two-step analysis. I will first examine the cases that they cited and do an analysis of those, but also look for other cases that might have been left out and try to think, why might those cases have been left out? Do they bear on the question? Are they helpful in answering the question? And if so, we'll include them. And certainly we include cases that are required. So the question that we get to then is, well, what cases are similar and what are different? What kind of differences are legally significant? And the question that I will generally ask is, what is the controlling terminology? What are the issues in our case that other cases have considered that we can find facts to make similarities and differences, highlight those? One way of thinking of this is, for example, if we have a situation where the issue is a plain sight search. An officer, in our case, conducts a plain sight search, finds something. Well, we would want to know what constitutes a plain sight search. What is plain sight? And then we would look at other cases where it was permitted or not permitted, where the court either blessed that decision by the officer and said okay, or threw out the search, the fruits of the search, for example. And then we would compare that to the facts of our case. And there's some ways to do that. When we're looking at the cases and we're comparing them, contrasting them, obviously we look at that binding versus persuasive nature, whether they actually bind the court or not. We also look at the facts themselves, the rationale for that holding in the other case that we're comparing. Did the court decide that case on the facts or on some other procedural issue, for example? How old is the case? Is the case many, many decades old, and have laws been passed since that case that didn't exist back then that would change the analysis today? That's a very important, fruitful area of consideration. We also look at those sort of subsequent changes in the law and how they might be applied in our case that they weren't applied 40 or 50 years ago. And of those different, and those are not all the factors, by the way, there's many of them, but of those, I want to talk about two that I really think are very helpful. The first is relatedness, and the second is composition. So for relatedness, we want to know how the facts relate. For example, if it's an identification case, well, the problem in a prior case might be that the witness who identified the suspect was too far away, and so the ID was thrown out, just for an example. Well, in our case, we might not have the distance, but we might have a witness who, for example, couldn't see real well. Well, those are different facts, undoubtedly. Distance and eyesight are different. But they kind of bear on the same issue, the same concern. If the court's rationale in the prior case with distance was the inability to perceive and observe well, then in our case, if eyesight is a problem, that would be a fact we would want to bring up, and we would want to compare, analogize that fact to the distance issue in the prior case. For composition, what composes the problem that the prior court looked at, and how does that affect our case? So for example, the plain sight analogy. If there's a plain sight search and the court says, for example, well, we're going to toss out the search because it was dark out and the officer really couldn't see, and that's why they moved something around. But that was a Fourth Amendment search and seizure warrantless, and it was impermissible, just for example, hypothetical. Well, we might have a case where it's not dark out in the same way, but where there's no ambient lighting. So in the prior case, it's nighttime, it's dark out, it's outside. But our case, it's daytime, but it's in a garage or it's in a covered area. And there's no ambient lighting, there are no street lights or overhead lighting. And so it was similarly dark, it's just ours was during the day and the prior search was at night. So there's two important points in this. One is looking at the composition of the rationale of the court in the prior case and how that might bear on a court's consideration of our case. But also, not all facts are directly linear. So just like the eyesight distance, you're not necessarily going to find the same fact in a prior case and go, aha, that's it, like that solves our problem. But dig deeper and be creative in examining the facts and what they mean. The last thing I'll mention is this point of ethics, that lawyers have an obligation to make good faith arguments to the court. There are very limited situations where lawyers can argue outside the current state of the law, and that's called extension, modification. But generally speaking, that's not what lawyers are doing. They're arguing, because our case has slightly different facts, Judge, we propose this result, and the other side can fairly and ethically propose a different result. It doesn't mean one lawyer is being unethical and the other is not. But there are bounds, there are restrictions, and one in particular that's very important in distinguishment is the idea of candor towards the tribunal. It just means honesty to the court. And lawyers have an obligation to be truthful to the court, not just in the representations they make. Lawyers have an obligation to be truthful about cases that hurt their case. So there's an obligation, at least in Florida law 4-3.3, it deals with candor towards the tribunal, and in particular, subsection A3 talks about the duty to disclose harmful precedent that's binding. So any precedent that's binding, that hurts our case, we have to tell the court about it. That's sort of the framework of distinguishment. I hope you enjoyed this video. If you have questions, leave them below, and we'll be back again to talk more about how to argue and win. Thank you.